On March 2026, in a Michigan Circuit Court, defendant Christopher Baller appeared via video conference from the Wexford County Jail for a plea hearing. Baller faced multiple charges stemming from a December 2025 incident, including 2 counts of assaulting, resisting, or obstructing a police officer and malicious destruction of property. The case took an unusual turn when his attorney requested a no-contest plea based on Baller's complete lack of memory due to intoxication, a legal maneuver that allows defendants to accept punishment without formally admitting guilt.
We can next get Mr. Todd Burns, please.
We may need a minute on that one.
Oh, okay. You need, is that still you, Mr. Harrison?
Yeah, he had indicated he wanted to speak with me.
All right.
We do intend to enter a plea. We do have the documentation. So if nothing else, I will take signature.
All right. Versus Christopher Baller, file numbers 26-14186FH, appearances from counsel, please.
Nick Carnes on behalf of the people.
Thank you, Your Honor. Taylor and Defendant on behalf of Mr. Bowler. And there's a matter of housekeeping we must address for the record.
Okay. Let's wait for Mr. Baller to join us, and I
Thank you.
was hoping we get him there before he's finished.
They have not.
He's someplace else.
He's in our jail.
He's in our jail. Mr. Aventa, why don't you go ahead and describe to me what the housekeeping matter is?
Thank you, Your Honor. So we need Mr. Bowler's signature on 2 documents other than 2 documents. First, the advice of rights. And
As
second,
long as you give them to me, I'll take them and I'll just cover the advice of rights, but you can give me the trial agreement sheet. So just go ahead and provide them both to me and I'll go over the advice of rights with him and I'll make that note above the signature. Thank you.
Thank you, Your Honor. I will state for the record, I did have a phone call with Mr. Bowler on Friday. We had reviewed the advice of rights, and I just got the plea agreement itself now, but we knew the content ahead.
I got it. No problem. Thank you.
The May approach.
Yeah. Thank you. Sure, Aventa, would you like to sign on the pre-trial agreement sheet? So I can show
Oh,
you?
yeah, sorry.
Okay.
The May approach.
Yeah, of course.
Thank you.
All right, we are now joined by Mr. Baller, who joins us via Zoom from the Wexford County Jail. Mr. Baller, can you see and hear the court this morning, sir? Mr. Baller, we're here today for a plea that the parties have reached and is documented in a written pretrial agreement. I'm going to go over the terms of that agreement with you in just a moment. But is that what you understand that you're here for today?
Yes, Your Honor.
All right, thank you.
May I provide those signed
Yeah,
documents
yeah,
to the
yeah,
bench,
yeah.
Your Honor?
Yeah, thank you. Mr. Ballard, please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hands. How many times do you guys amend the felony warrant? 3. Yeah, I know.
I thought a desk was a fixture. It's fine. We sorted it all out.
Yeah, that is true. A desk is
Okay.
not a
I'll
fixture.
stand corrected. I was wrong.
Okay.
Set it on the record.
The court initiated a plea hearing for Christopher Baller, who appeared remotely from jail. The judge began by establishing the defendant's identity, confirming counsel's presence, and administering the oath, standard procedural safeguards before accepting any plea. Under Michigan Court Rule 630 SOC, a court may not accept a guilty or no contest plea without first determining that the defendant understands the nature of the charge and the consequences of the plea. The rule requires judges to personally address defendants on the record to ensure voluntariness and comprehension. Additionally, the Sixth Amendment, as applied to the states through the 14th Amendment, guarantees criminal defendants the right to counsel at all critical stages of prosecution, including plea hearings, as established in Boykin v. Alabama, 1969, which held that courts must affirmatively establish that guilty pleas are entered voluntarily, intelligently, and with full awareness of the rights being waived. Here, the judge meticulously follows Rule 602 by first confirming Baller can communicate effectively via video conference, a practical necessity given his custody status before proceeding. The oath administration serves dual purposes. It establishes the solemnity of the proceeding and creates a record for potential future challenges to the plea. The judge's confirmation that Baller understands the purpose of the hearing demonstrates the intelligent component of the Boykin requirements, ensuring the defendant comprehends the basic nature of the proceedings before any waiver of rights occurs. These procedural safeguards exist because plea agreements resolve approximately 90% of criminal cases without trial. A defective plea can be overturned years later, wasting judicial resources and potentially releasing dangerous offenders or, conversely, wrongfully imprisoning those whose pleas were coerced or uninformed. The video conference format, increasingly common post-pandemic, requires courts to take extra care to ensure defendants can fully participate meaningfully in their own defense.
Mr. Ballard, looking back here on the date of December 23rd of 2025, in other words, about 3-4 months ago, were you on probation or parole on that date, sir?
Yes, Your Honor.
And was there a probation violation or a parole violation handled?
Yes, Your Honor.
Was that in this court?
Your Honor,
Oh, hold on.
sorry.
I should have asked you the question, was it a parole violation or a probation? Miss
parole.
Lindsay Sim. All right, there we go. Miss Lindsay Simmons is also here before the court. She is an agent with the Michigan Department of Corrections. All right, thank you. So that means that you're on a parole hold. Is that correct?
Yes, Your Honor.
So if you enter a plea today, and I accept that plea, any sentence that you're given in this file would have to run consecutive to any sentence for which you would serve for a parole violation. Now, that doesn't mean that the parole board is going to violate you. That's up to them. But if they did and sent you back to prison, let's say it was for 6 months. Well, this sentence wouldn't begin to run until after you had served that 6 months. That's what we mean by using the phrase consecutive sentence. Do you understand?
Yes, Your Honor.
All right, thank you. At this date and time, back in December, were you on bond pending any other felony charges anywhere?
No, Your Honor.
Mr. Baller, you are currently charged on a felony information with 5 counts, as well as a sentencing enhancement. I will go over that with you. I'm going to cover the terms and conditions of the pretrial agreement as we go through it. Count 1 is a charge of assault, resist, obstruct a police officer. That is a felony punishable by up to 2 years and or up to $2,000. And there's a 4th habitual felony offender enhancement that could increase that maximum punishment from up to 2 years to up to 15 years. Another, Mr. Carnes, is that alleged assault, resist in a jail?
No, it was in the DOC office.
Okay. Count 2 is a charge of malicious destruction of a building where the value of the damage was at least $200, but less than $1,000. That is a misdemeanor punishable by up to 1 year and or up to $2,000, or 3 times the value of the destruction, whichever is greater. So far, those 2 counts will be dismissed.
The judge conducted a detailed inquiry into Baller's parole status and explained the concept of consecutive sentencing, where multiple sentences must be served one after another rather than simultaneously. The judge then began reviewing the specific charges and the plea agreement structure, including which counts would be dismissed. Under Section 768.7a of the Michigan compiled laws, when a defendant commits an offense while on parole, any sentence imposed for the new offense must run consecutively to any sentence imposed for parole violation. This statutory scheme reflects legislative intent to impose enhanced accountability on supervised offenders. The Habitual Offender Statute, Section 769.12, permits sentence enhancement for defendants with prior felony convictions, here elevating potential exposure from 2 years to 15 years for the assault charges. The plea bargaining process, governed by Michigan Court Rule 6302.c, allows prosecutors to dismiss charges in exchange for guilty pleas, provided the court independently verifies the defendant's understanding of the agreement. The judge's explanation of consecutive sentencing was legally mandatory under Section 768.7a. Defendants must understand that their new sentence won't begin until any parole revocation sentence concludes. This dramatically affects the actual time served. The judge's methodical review of each count, distinguishing between those to be dismissed versus those requiring pleas, demonstrates compliance with Rule 6302, C's requirement that defendants comprehend the nature and extent of their plea agreements. The prosecutor's clarification about the location of the alleged assault, DOC office, not jail, subtly highlights how factual nuances can affect charge severity and venue considerations. Consecutive sentencing provisions can transform a relatively short sentence into years of actual incarceration, yet many defendants focus only on the nominal length of their plea deal. Courts must ensure defendants understand this stacking effect to make truly informed decisions. The dismissal of counts 1, 2, and 5 in exchange for pleas to counts 3, 4, and an added misdemeanor count illustrates prosecutorial discretion and charge bargaining tools that conserve resources but raise questions about whether the final charges accurately reflect the defendant's conduct or merely represent the path of least resistance.
Count 3 is a charge of assaulting, resisting, or obstructing a police officer, which is a felony punishable by up to 2 years and or up to $2,000. Plus, there's the 4th habitual felony offender enhancement that could, within the discretion of the court, increase that potential punishment from up to 2 years to up to 15 years. However, I'm told that if you plead guilty to that count, the habitual enhancement will be dismissed, which means instead of facing up to 15 years, you'll still only face up to the basic minimum of up to 2 years. Do you understand so far?
Yes. Yes, Your Honor.
Count 4, all right. So I'm told you're going to plead guilty to that count 3. Count 4, I'm also told that you're going to plead guilty to it. This is another charge of assault, resist, obstruct a police officer. Again, a felony punishable by up to 2 years and or up to $2,000. And again, because of the pretrial agreement, the habitual 4th enhancement that could have increased that maximum punishment up to 15 years will be dismissed. Now, count 5 is a charge of malicious destruction of property. Count 5 is another charge of malicious destruction of property where the value is at least $200, but less than $1,000. And then there's a second or subsequent enhancement. So initially, it's a misdemeanor punishable by up to a year and or up to $2,000 or 3 times the value of the damage. But as a second or subsequent enhancement, that could have been increased up to 5 years and up to $10,000 or 3 times the value of the property damaged. That count will be dismissed. So far, you're pleading guilty to count 3 and count 4. Both are a charge of assault, resist, obstruct a police officer. Now, I'm told you're also going to plead guilty to an added count 6. An added count 6 is an attempt to commit count 1, which is, again, hold on, I'm sorry, take that back. I misunderstood how you wrote it out here, but I got it now. So take that back. So again, we've got you pleading guilty to counts 3, count 4. Then you're going to plead guilty to an added count 6, which is really count 5 without the enhancements, which means you'd be pleading guilty to added count 6, a misdemeanor of destruction of property value between $200 and $1,000. Yes, Ms. Fervento?
Your one quick amendment, Your Honor, I do apologize for not catching this. Would the court entertain a no contest due to intoxication and lack of memory based on the plea? I did discuss this with my client on Friday.
I don't know, it depends what he says.
Your Honor, I'm fine with that. I think it is supported by, I think in the police report, certainly, I think DOC would say he was intoxicated at the time. I'm getting it, not yes.
Mr. Ballard, do you remember these events?
No, Your Honor.
Go ahead and have that marked. All right, so again, guilty to count 3 and count 4, assault, resist, obstruct a police officer, and guilty to added count 6, which is malicious destruction of property with a value of $200 to $1,000, which is the same count as count 5 without all the enhancements. And that is that last one is a misdemeanor punishable by up to a year and or up to $2,000. I don't know why you just didn't have, well, guilty to count 2, but that's all right. Anyway, so far, Mr. Ballard, is that what you understood to be the terms of your pretrial agreement?
Yes, Your Honor.
Now, there's another term of the agreement, and that is that you're going to agree to pay an amount of restitution of $1,227.87 payable to Wexford County, which is for the restitution involved in the destruction of property count added count 6. Do you understand?
Yes, Your Honor.
Mr. Carnes, did I get all the terms and conditions of the pretrial agreement that's presented on the pretrial agreement form signed by you and Ms. Fiorvento.
Yes, Your Honor.
Ms. Fiorvento, do you agree?
Yes, just with the amendments discussed today.
Yeah. All right, so I kept using the phrase guilty, but I'm now told you're gonna plead no contest. A no contest plea has the same impact as a guilty plea. The difference is instead of requiring you to recite a factual basis, the law allows me to look at something else such as a police report. I can take a no contest plea in certain circumstances. One of them is which is the defendant due to intoxication or being under the influence does not recall the events, but doesn't challenge them based upon his own knowledge of the case. You understand, Mr. Baller?
Yes, Your Honor.
Thank you. Now, by entering this plea that we've discussed today, you're not going to have a trial of any kind. By entering that plea, you'll be given up or waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury if you chose to court and the prosecutor consented. The right to be presumed innocent until proven guilty, proved beyond a reasonable doubt that you are guilty. The right to have the witnesses against you appear at the trial. The right to question and cross-examine those witnesses against you. The right to have the court order any witnesses you may have for defense to appear at the trial. The right to remain silent during the trial. The right to not have its silence used against you. And the right to testify if you were to choose to testify. Mr. Baller, do you understand those rights?
Yes, I do, Honor.
You understand that if you enter a plea of no contest today, and I accept that plea, you will be waiving those rights as it applies to this particular case.
Yes, Your Honor.
Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told me today on the record. Have there been any other promises, threats, or inducements that we haven't talked about yet?
No, Your Honor.
Are you into the plea so far of your own free choice?
Yes, Your Honor.
Now, if your plea here is accepted, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing an app and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Now, Mr. Baller, we've talked a lot about the plea and the charges so far. I assume that Ms. Fiorvento was talked to you about potential sentencing and something called the Michigan Sentencing Guidelines. Is that correct?
Yes, Your Honor.
Key is I want you to know that whatever the guidelines score and whatever she's told you right now is just an estimate. We don't know exactly how they're going to score. It's just an estimate. Also, whatever those guidelines recommend for the minimum end of your sentence is merely that. It's a recommendation. They are not binding upon. Has anyone made any promises to or asserted to exactly what I would do for a sentence in this case?
No, Your Honor.
Now, Ms. Fiorvento, has she been able to answer all your questions and been responsive to making sure you understand what's going on?
Yes, Your Honor.
Are you satisfied with her advice and counsel thus far?
Yes, Your Honor.
Do you believe accepting this plea today is in your best interest?
Yeah.
Maybe it's not what
Yes.
you want to do, but don't worry.
Yes, Your Honor.
Thank you. All right, so I'm going to go over it. And again, I expect that you're going to tell me the phrase no contest. I'm not telling you what to plead, but I'm just told that it's going to be a no contest plea. So as to take it back, count 3 and 4, assault, resist, obstruct a police officer. How do you plead?
No contest.
As to add count 6, attempt to commit, not attempt. As far as malicious destruction of property as a first offense, a misdemeanor where the value is between $200 and $1,000. How do you plead?
No contest.
Thank you. Mr. Carnes, do you believe that the interests of justice based upon intoxication do not require the court to require the defendant to recite a factual basis?
Yes, Your Honor.
Ms. Fiorvento, do you agree?
Yes, Your Honor, we ask court accept the plea.
All right, well, I have right now People's Exhibit number 1. That's a City of Cadillac Police Department report, incident number 25-3640. Mr. Carnes, are you asking the court to accept that for the taking of the plea and sentencing?
Yes, Your Honor, that incident report, and there's also a report emailed by Agent Van Acknell
That's attached
that's
to it.
attached to that.
So let me just say that this exhibit not only includes the 7 pages of the report, but also includes a email that appears to be prepared by Mr. Van Atmel, and it has some attachments to it. And those are all considered part of exhibit number 1. Ms. Garavento, does the defense so stipulate the admissibility of that exhibit?
Yes, Your Honor, thank you.
People's exhibit number 1 is hereby admitted. Give me just a moment to take a look at it. The court notes on page 1 and carrying on to page 2, the date, time, and jurisdiction are addressed. The court also notes that beginning on page 2, there is evidence to show that there was conduct for 2 probation officers, Mr. Saladay and Mr. Van Atmel. All right, the court also sees that continuing on to from page 3 on to pages 4, 5, and 6, there is some damage to property. Mr. Cars, do you believe the report satisfies the factual elements for 3 counts?
Yes, sir.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with Scroll 6.302?
Yes, Your Honor.
Ms. Garavento, do you agree with all 3? The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that based upon the information we've already discussed on the record, specifically the amount of intoxication, that the interests of justice do not require the recitation of defendant. Therefore, the no contest plea is appropriate. And the court also finds the defendant is guilty of count 3. The remaining counts and enhancements will be dismissed at the time of sentencing.
The judge formally accepted the defendant's no contest plea, admitted the police report as evidence, and made specific findings on the record that the plea was knowing and voluntary while waiving the defendant's personal recitation of facts due to his intoxication and lack of memory. Under Michigan Court Rule 632b, a court may accept a guilty or no contest plea only after determining that the defendant understands the nature of the charge and the consequences of the plea, and that the plea is voluntary and not the result of force, threats, or promises apart from the plea agreement. The rule further permits courts to waive the defendant's personal recitation of the factual basis when the interests of justice so require, a provision particularly relevant when defendants have impaired memory due to intoxication or mental health conditions. Additionally, Michigan Compiled Laws Section 768.35 establishes that no contest pleas carry the same legal effect as guilty pleas for sentencing purposes while preserving the defendant's ability to deny civil liability. Here, the judge methodically verified compliance with Rule 630.02 through the prosecutor and defense counsel, then explicitly found that the defendant's significant intoxication justified waiving his personal factual recitation under the interests of justice standard. The court's admission of the police report as Exhibit 1 provided the independent factual basis required to support the conviction, satisfying due process concerns while accommodating the defendant's genuine inability to remember events. This procedural accommodation reflects a crucial balance. Courts must ensure pleas are factually grounded without forcing defendants to fabricate testimony they cannot honestly provide. The interests of justice waiver prevents perjury while maintaining integrity. Defendants cannot escape accountability by claiming memory loss, yet they need not falsely confess to details they cannot recall. This safeguards both the defendant's rights and the court's truth-seeking function.
Mr. Bauer, between now and sentencing, which will be in about 4 weeks, we do them every Monday morning, a pre-sentence investigation report must be prepared. One of these reports must be prepared anytime someone is convicted of a felony in a state court here in Michigan. This report will include a description of the offense, description of the pretrial agreement, any statements or information you make or provide, information about prior criminal history, performances of bond, parole, or probation, any statement from the victim if there are any made, and it will include a score into the sentencing guidelines. Please keep in mind that that is merely a recommendation and they are not mandatory. Also include a recommendation as a sentence, and that recommendation is also strictly that, just a recommendation. There are 3 steps that involve you in the preparation of this report. First, you will receive a packet at the jail. You're going to complete that packet and turn it back into the Department of Corrections. Number 2, you'll be subject to an interview with an agent from that office, and you have the right to have your counsel present at the time of that interview. And third, your counsel will meet with you when she gets this report, and will come and talk to you and see if there's any need for corrections or objections to be made here before the court. You understand, Mr. Baller, about what we have done today?
Yes, Your Honor.
Do you have any questions for me at this time, sir?
No, Your Honor.
Anything, Mr. Carnes?
No, Your Honor.
Anything, Ms. Firavento?
I think, Your Honor, if we may motion for a modification of bond pending now sentencing. I discussed with the prosecutor briefly before coming on the record.
Mr. Carnes, any objection to?
I waived the timeline.
Thank you, Ms. Firavento. You may begin.
Thank you, Your Honor. The defendant here has been working diligently to try to secure a bed in a rehabilitation facility. We do have potential acceptance pending, but we needed to have some sort of rough release date or some sort of rough idea of what was going to happen next. So we needed to secure this plea for his rehab to work with us. He also reports that he's been voluntarily participating in service as well at the Wexford County Jail. In light of those things, we would respectfully request that we could get a bed admit letter that this court would allow Mr. Bullard to be released to treatment pending sentencing. And we would gladly stipulate to any waiver or adjournment of sentencing so he could complete that treatment. He is young, Your Honor. He is committed to getting his life on track. He realizes that he ended up in this situation due to a substance problem. And the goal here is to get him back on track and make him a productive member of our society.
What is one obstacle?
The judge explained the pre-sentence investigation process and the defendant's rights during its preparation, after which defense counsel moved for bond modification to allow release to substance abuse treatment pending sentencing. Michigan compiled laws section 771.14 mandates that pre-sentence investigation reports be prepared for all felony convictions containing specific information including criminal history, social history, and sentencing guideline calculations. Under Michigan Court Rule 6.425, defendants have the right to counsel's presence during PSI interviews and may file objections to factual inaccuracies before sentencing. Regarding bond modification, Michigan Court Rule 6.106 permits courts to reconsider bond conditions at any stage of proceedings, though defendants on parole face additional constraints. Under Michigan compiled laws section 791.238, the parole board retains exclusive authority to approve release from custody for parolees, regardless of court orders. Defense counsel sought to leverage the defendant's proactive treatment efforts to secure pretrial release, offering to waive speedy sentencing rights to accommodate rehabilitation. However, the prosecutor's opposition, citing the defendant's history of absconding from treatment and the judge's acknowledgement of parole board jurisdiction, revealed the structural limits of court authority over parolees. The judge indicated willingness to modify bond if the parties stipulated and the parole board approved, but emphasized that court orders cannot override parole hold authority. This exchange illustrates the complex jurisdictional layering in criminal cases. Trial courts control case disposition but share, or in parole matters, subordinate authority over physical liberty with administrative agencies. The parole board's independent power to detain creates a second custody that frustrates well-intentioned judicial efforts at rehabilitation. This systemic tension between punishment and treatment paradigms frequently traps defendants in custody despite judicial and defense agreement on appropriate alternatives.
A motion for a modification of bond pending now sentencing. I discussed with the prosecutor briefly before coming on the record.
Mr. Carnes, any objection to?
I waived the timeline.
Thank you, Ms. Firavento. You may begin.
Thank you, Your Honor. The defendant here has been working diligently to try to secure a bed in a rehabilitation facility. We do have potential acceptance pending, but we needed to have some sort of rough release date or some sort of rough idea of what was going to happen next. So we needed to secure this plea for his rehab to work with us. He also reports that he's been voluntarily participating in service as well at the Wexford County Jail. In light of those things, we would respectfully request that we could get a bed admit letter that this court would allow Mr. Bullard to be released to treatment pending sentencing. And we would gladly stipulate to any waiver or adjournment of sentencing so he could complete that treatment. He is young, Your Honor. He is committed to getting his life on track. He realizes that he ended up in this situation due to a substance problem. And the goal here is to get him back on track and make him a productive member of our society.
What is one obstacle, Mr. Carnes?
Does the parole hold, Your Honor, as an obstacle?
We are aware of that.
So if you all present a stipulation that says he can be released to a program on a particular day, attaching to that stipulation a letter of that acceptance, I will modify his bond and send him to that program. And we'll even adjourn sentencing far enough out for him to be able to complete any programming and to reap the best benefit from it. However, of course, that requires you to get the permission from the parole board, because I am not in charge of the parole. So you can present one,
Your Honor.
but it doesn't do anything unless you get the parole board.
Your Honor, the people are opposed to this. I don't want to discourage Mr. Bowler in his recovery. I hope he's making those steps, but he has absconded from treatment in the past.
Oh.
He's on parole for R&O. I'm just opposing it
If
for
you're
those
not,
reasons.
all right, so if you're not going to stipulate to it today, then it takes everything I just said and throws it in the trash bin. So that means there would have to be a motion, and I would want to know that. However, the defense is spitting into the wind because it takes parole. So, parole board, I mean, to release it. And since no one here works for the parole board, I don't see that happening. So it's a good request, but I'm not in charge of answering it. So, all right, so right now, any bond modification is denied based upon the fact that he's got a parole hold. Thank you. We are adjourned.
Your Honor, may I retrieve my exhibit?
Sure. Do we have Mr. Perkins joining us? We get Mr. Eventual out of here.
He will be on Zoom
All right.
from our jail as well, and we have.
The court formally accepted Christopher Baller's no contest plea to count 3, assaulting, resisting, obstructing a police officer, with the habitual 4th enhancement and remaining counts to be dismissed at sentencing. The judge found the plea knowing, voluntary, and intelligent under Rule 6302, specifically waiving the defendant's personal factual recitation due to his intoxication. Sentencing was scheduled for approximately 4 weeks to allow completion of a mandatory pre-sentence investigation report. Defense counsel's motion for bond modification to permit release to substance abuse treatment was denied due to active parole holds and prosecutor opposition citing the defendant's history of absconding from treatment. The judge indicated he would have granted the modification with a stipulation and parole board approval, but emphasized that the court lacks authority to override parole jurisdiction. Mr. Baller remains in custody at Wexford County Jail pending sentencing, with no bond modification granted. This case illuminates the tension between judicial rehabilitation efforts and administrative parole control, a systemic feature of American criminal justice where multiple government actors exercise overlapping custody authority. The judge's explicit acknowledgement that he was not in charge of answering the release request, despite controlling the underlying case, reveals how parole systems can frustrate individualized justice even when courts, prosecutors, and defense counsel align on treatment-oriented outcomes. This jurisdictional fragmentation reflects deeper policy choices about whether post-conviction supervision serves public safety or rehabilitation, and whether administrative efficiency should override judicial discretion in liberty decisions. If you found this analysis of plea procedures and parole jurisdiction valuable, explore our complete series on Michigan criminal procedure, including our deep dive on how sentencing guidelines interact with judicial discretion. Subscribe for weekly court case breakdowns, and let us know in the comments whether you believe parole boards should have authority to override judicial release decisions or if courts should control custody throughout the criminal process. Thank you for watching.